Hi everyone, in this video we're going to be looking at 3 things to know when entering to or indeed about no-win, no-fee agreements, and we're going to be focusing on this in an employment law context. Hi, my name is Roy Magara and I am a solicitor advocate at Magara Law. Let's jump in. 1. No-win, no-fee agreements are typically called or commonly known as conditional fee arrangements, or CFAs you may have heard of. In employment law, we often use something called a damages-based agreement, or a DBA. Now, DBAs often focus on the damages that an employee receives after they have won their claim. And as the name suggests, there is indeed a condition where if you don't win, you don't pay anything. However, you need to be aware that there may still be things you need to pay for, like expenses or disbursements. And these are typically things like barrister's fees if a barrister doesn't enter into the DBA themselves. There may be medical fees, for example, attached to that, or any other kind of expert fees which you need to take into account. So while you may not necessarily be paying your solicitor, you may end up having to pay for other experts. So that's something to keep into account. Secondly, your case needs to have a good chance of success in order to get signed up for a DBA. You're not going to find a solicitor unless they're just completely desperate. You're not going to get a good quality solicitor who's going to enter into a DBA if you haven't got what we would say a good chance. So that's anywhere from 51% onwards. Typically around 60% is the comfort zone in terms of whether to enter into a damages-based agreement or not. You also got to be aware that litigation in and of itself can be extremely stressful, emotionally draining, time-consuming, and DBAs are great because they can take away that financial pressure, but nonetheless, you're still going through that process. And good quality solicitors will make sure that they can gauge and see whether your case has got a good chance of success, so that even if you don't necessarily have to think about the financial side of things, all these other elements that you've still got to think about and that you will think about are going to be balanced accordingly when it comes to that risk analysis. Lastly, what sort of portion is taken out of your damages on a DBA? Well, solicitors can take up to 35% of whatever damages you receive. So for the sake of argument, if you eventually get £10,000 in the way of damages, you will pay, depending on when you sign it and what the clauses and rules are that govern your DBA with your solicitor. If it is agreed that the solicitor will take 35%, then they will take £3,500 of your damages, and then you will keep the balance of that. Again, this is a good way of you taking off the financial pressure, and it also means that your solicitor, who is taking the risk of potentially not being paid, is adequately compensated in some way, shape or form. So these are 3 things that you've got to think about when entering into a no-win, no-fee. If you go into our website, which is magaralaw.co.uk, you will find 6 other things to think about. And indeed, you're more than welcome to get in touch with me, Roy Magara. My email is roy@magaralaw.co.uk. Details are below. And we can have a discussion if indeed you believe you've got a case. There's plenty more detail on my website. You're more than welcome to get in touch. Thank you.